Thank you. Welcome, everybody. This is the House General and Housing Committee, and it is just about 10 after 3 on Tuesday, February 25th. And we are going to hear from one more witness dealing with this appeals and appeal issues relating to housing. John, I think do you know the committee?
Not really, no, I don't.
Why don't we introduce ourselves to you? You want to start?
Sure. Rep. Emily Krasnow, Chittenden, South Burlington.
Me?
Yeah.
Hi, I'm Elizabeth Burrows and I represent Windsor One, which is Heartland, West Windsor and Windsor.
Nice to meet you.
Nice to meet you.
Hi, Chittenden 20, Colchester, Gail Pezo.
Nice to meet you.
You too. Debbie Dolgan, and I represent St. Johnsbury, Concord, and Kirby.
Oh,
Tom Charlton. I represent Chester, Athens,
Nice to meet you.
Parsons, Newbury, Thompson, and Groton.
I live in Marshfield. I spend most of my time in the Groton Forest. So
Beautiful spot.
it is, yeah.
Ashley Bartley, Fairfax in Georgia.
Nice to meet you.
Holly, Plainfield, Marshfield, Dallas.
Nice to meet you.
John, you want to introduce yourself?
Sure.
Take it away.
So thanks for this opportunity. So my name is John Groveman. I'm the Policy and Water Program Director for the Vermont Natural Resources Council. I work on, like any nonprofit, we wear lots of different hats. So I work on water issues, but I also work with the other VNRC programs on all their issues. And VNRC, I don't know how much you know about VNRC. We're Vermont's oldest and largest in-state environmental group. Over 60 years old. We were started by foresters and farmers, around the time when the interstates were built and there was a lot of development pressure in Vermont, mostly to try to address development pressure on working lands. But now we have 4 programs: a water program, forest program, climate and energy program, and a sustainable communities program that deals a lot with land use, zoning, and Act 250. And you'll hear from my background that I've worked a lot on land use issues. So as a policy director, I spend a lot of time on those issues. So I'm going to talk about the appeals part of the committee bill. So I thought it would just be helpful to give you the context that I come to this issue. So from 1995 to 2000, I was what they called the Act 250 land use attorney for the Agency of Natural Resources. So I represented A&R and actually all the agencies before the Act 250 district commissions and then in appeals that at that time went to the Environmental Board. I also was the director of what was the Water Resources Board that used to hear A&R of water permit appeals. So I saw sort of appeal adjudication from like the lead staff person for the state appellate board. And then as both a VNRC attorney and I was the general counsel for A&R, I participated in numerous appeals in the environmental division of the Superior Court, which now hears all of these different appeals. And I'll talk a little bit more about that, when I try to give some background and give you a foundation for some of the appeals changes that you're considering. And then lastly, I for 2 years, in the mid 2015, from 2015 somewhere to 2020, I was the chair of the Natural Resources Board. So I was responsible for administering Act 250. So I saw the whole program, including the appeals and how that works. So just to give you a sense of sort of kind of my experience and sort of how I come to look at these issues. So I thought it would be helpful. I listened to a lot of the testimony in this committee about appeals. I thought it would be just helpful, and Ellen did a good job and hit on a lot of these themes earlier, but I thought it would be still useful to emphasize some background about how appeals are handled in Vermont and kind of how we got to the system that we have today. And as we change it, so what are some of the considerations? And these are not new issues. We've been talking about changing the appeal system for a decade. And in fact, as I will talk about in a second, 20 years ago, we made a significant change to the appeal system. So 20 years ago, 2004, Vermont made a big shift in environmental appeals. And we went from various boards hearing appeals that I mentioned in my intro. The environmental board was a 9-member citizen board. It heard Act 250 appeals. The Water Resources Board was a 5-member citizen board. It heard A&R permit appeals. And there was a waste facility panel that heard, it was also a 5-member citizen board. They heard appeals of A&R permits related to waste management issues. And the environmental court, and it was called the environmental court at that time, now it's called the environmental division of the Vermont Superior Court. They heard zoning appeals and they handled enforcement appeals from A&R, Act 250, and zoning. In 2004, the environmental court's jurisdiction was greatly expanded. We got rid of the environmental board for Act 250, hearing appeals. We got rid of the Water Resources Board, hearing A&R water appeals. We got rid of the waste facility panel, and we put all the appeals in the environmental court. So that was after a lot of debate around a lot of the same issues that, we're talking about today, about efficiency of hearing appeals and effectiveness and how long that it takes. But that was something that had a really major effect on appeals. I did want to, just as background, also really point out what Ellen pointed out, which was that both in the former system, when you had the environmental board and the water resources board and the waste facility panel, and now with the environmental division, the appeals are de novo. And it means that in Vermont, when there is an appeal to the court, it doesn't matter what happened before A&R, it doesn't matter what happened before the district commission, it doesn't matter what happened before the zoning authorities, you start all over again in court. And all the evidence that came in before A&R and Act 250 and zoning is irrelevant. The court does not, it's just not relevant. Not that they don't care about it, they can't consider it. All the evidence comes in all over again, and we kind of start all over again. And the environmental court stands in the shoes, basically, of A&R, the district commissions, and zoning, and makes its own decision based on the evidence in the record on the appeal. That's very unique, especially with regard to zoning and A&R appeals. I think we're the only state in the country, especially with A&R appeals, that does this de novo review, that, basically doesn't look at the record that was established before whatever the natural resource agency is in that state. And that's because, those decisions coming out of A&R and the A&Rs all over the country are very technical, right? Whether it's wastewater or water supply or stormwater or, landfill issues, they're really technical scientific issues. And the law really around the country, and with the federal government, and works this way with EPA, is that those agencies make those decisions, they create a record, and when you get to court, they're not technical experts, like courts are not technicians. So they don't stand in the shoes of the Natural Resource Agency. They basically look at the record, they look to see if the agency's decision was clearly erroneous or they've used discretion. Those are the very typical standards. So they're looking at paper, new evidence isn't coming in. It's a much quicker process, and it really is very deferential to the technical permitting agencies. And similarly with zoning, most courts around the country, they hear the zoning issues, I think on the record as well. And Ellen did mention in Vermont, we did probably 20 years ago or more, allow towns to have on the record review for zoning. Towns have to adopt what they call the Municipal Administrative Procedure Act, or MAPA. And if they do, their appeals become record review. There's a handful of towns. I lose track of how many, 5, 8, or 9, 9. I don't know the exact number, but it's the vast minority of towns. And the issue has always been, and I think one of the reasons we have de novo appeals in Vermont, and this is something that is continued to be discussed, and I think it should, is because our towns are small, and there's been issues creating a record, because when you create the record, you have to make decisions about evidence, what comes in, what doesn't come in. Lawyers get involved like right away. And I think we made the decision in Vermont, and I think there's good reasons for it, that, Vermont we want an informal process at the beginning where people can come and they could try to resolve issues without bringing lawyers and getting into all of that. So we basically put the weight on that rather than creating, a record at that first level. But it does put a lot of pressure on the appellate level when you do that.
John,
Yeah.
is there any reason for this usual de novo review other than we thought that there just was so many towns that really weren't able to produce a record?
I think in zoning, it was more like the ability of towns to remember, this was before, and some of the discussion that we've been having now is now the Zoom, right? Everyone's Zooming the hearings and recording them, like the recording capability. Like this is going back to the 70s, didn't exist. So they're really like people would literally, I'm sure we've all seen it, like run the tape recorder, but they literally have a tape recorder and a tape, And I'm aware of situations where the towns that try to adopt the MAPPA and have record review, they send the tape to the court and you couldn't hear it. It was all garbled, they had to send it back to them to do it over again. So I do think we should revisit it, but I think because technology has improved so
Is
much.
there any discussion of simply giving developers and towns the right to just pay for a court reporter to come in?
I don't know. That's a good question. There should have been, if there hasn't been.
Okay,
But I think it really was that issue. With A&R, it was, I think what happened with A&R is that, remember, we had this Citizen Water Resources Board and Waste Facility Panel. And while they were citizens, which means they were like on per diem, the way you all are when you do study committee, they were experts too. Like they were appointed by the governor, they had qualifications. And I think the feeling was that they had some expertise in the area. And so you could do a de novo review. And then Act 250 is just our own special Vermont thing that other states don't do, really, for permitting. And I think that they built in that the environmental board was going to be experts like the district commissions, and they should be able to do this de novo review. But when we shifted to the court, we didn't change any of that. We just left it all in place. And so I think that's part of the discussion. And I'll talk about the study that's going to be happening this year. But I think those are some of the issues that need to be discussed because we've come a long way since even 2004 when we've made these changes that altered the system in the way I described it.
go ahead.
I just want to summarize, and so I want to make sure I heard you correctly. So we had a system set up that put experts into positions of decision making at the lower level to begin with.
Mm-hmm.
And when you appealed, or that's who you appealed to?
There were both for A&R and Act 250. I would argue that there were certainly at A&R there were experts making the decision, and then there were people with specific qualifications like in water and waste that heard those appeals.
Right,
I think district commissions also got vetted, and it's a mixed bag of who gets on those district commissions, as I'm sure you've all seen. But
so when
Yeah.
it switched, I'm sorry to interrupt.
yeah, please, ma'am.
But then when we updated to having the hearings, broadening the environmental division, we don't necessarily have the same expertise in the courts.
Right. Yeah, I mean, well, judges are legal experts.
Yeah,
They're jurists, but they're not technical experts. They certainly have developed one judge has been doing this for 15 years, and then the judge that was appointed has been only doing it for a couple of years. Judge Durkin sadly passed away. He had been doing it for about 20 years. And certainly the governor, so the new judge that got appointed is Judge McLean, who is basically a zoning expert. So I think that the governor has tried to get expertise in zoning, but not necessarily in all the A&R technical issues, all the active. You can't find one person to know, that knows all those things. And
One thing that might help here for you is de novo review on the record, which usually involved a court. Because of the idea that you're referring to, that the people below are experts and they've spent endless amount of time on it. And then it goes up to a judge who's relatively a generalist, maybe less so in a special court, but still sort of a generalist. In most places, what the review is on the record doesn't just mean that they just read the record. It means the standard they apply is they have to agree with the decision below unless that it's so clear that it's called an abuse of discretion. In other words, they defer strongly to the decision below.
So they
Most
didn't give
practitioners-
people enough time that according to the deadlines.
Or
that are
they violated a
prescribed.
procedural law, or they just like, it was like, what? It wouldn't pass the lab test.
They ignored some piece of evidence in the record that was clear, and, you know, the lawyers can argue, say, look, there's this report. They didn't even cite to it. They did not reference it. So the judge could say, yes, well, good, they didn't do that, and that was a clear error.
And send it back.
Send it back, right?
Legal procedure,
Yeah.
not date,
Send it
not
back.
Yeah,
date.
they're not, yeah, right, they're not supposed to be subject matter.
But it could be so egregious on the subject matter that the judge will just say, oh my God,
Yeah,
there was really a bad decision. But I can literally, in 25 years of practice, could count on the fingers of one hand the number of times I even heard of a judge overruling a decision below when it was on the record. You know, the deference is enormous. So to have when you have de novo review, not only do you get to look at all the evidence all over again, but you decide whatever you want to
yeah,
decide.
you're like the permanent, you're like the whole zoning board, you're like all of the A&R division that made the decision. You are the district commission, you know, you are standing in their shoes, and you have to evaluate all that evidence. And I say all this just to give you background about, because I want to talk a little about this, because these are things that we're going to study over the next year. Yeah. So the last point on sort of this change is that I do think one of the issues that we want to deal with as we look at appeals, and there's a study that's going to go on to make recommendations for the legislature to consider next year, is when they gave all this extra work to the environmental court, there was so before they gave the court the extra work, there was one judge and one law clerk and maybe some administrative staff. They added one additional judge. So they went from one judge to two judges. They went from one law clerk to two law clerks. They added a court administrator, maybe another administrative staff person. And from the beginning, I think a lot of us felt that was not sufficient, you know, because basically like they went from having zoning and enforcement to zoning, Act 250, A&R, all their enforcement. It was a big leap. And I think and I don't blame the judges. They do a great job. They're doing the best that they can. But I just think that their docket is really heavy. It's a heavy docket. So things go slowly. Court is very procedural. Once you're in court, and because it's de novo, and that was one of the reasons I want to spend some time on de novo versus on the record, you're bringing in new evidence. That means there's discovery on all the new evidence. Every lawyer gets to do depositions and interrogatories. And then we have fights about what evidence gets into the record. And there are motions to dismiss and motions, procedural motions that have to get dealt with before you even get to the trial itself. So it is an intense process, and it's an expensive process, and it's slow. It's not, courts are generally slow. I'm a lawyer, and I've been involved with cases where citizens try to represent themselves, and at this point, I have to say it's almost impossible to be effective at it. I mean, you have to really know what you're doing to get involved with the court, but that does slow things down, and I think that leads to a lot of the frustration that people have with appeals. So, and so the last kind of background point is, so all the background I just given you, the predicate to Act 181 was the Natural Resources Board, which administered Act 250. Until now, we have the Land Use Review Board, which you've heard about.
They actually testified, and the chair and one of the members who's a lawyer testified.
Yeah, so they have a lot of the same staff, but
Study,
yeah. Before Act 181, there was a whole study to basically update, modernize Act 250. Substantively, the tiered jurisdiction that you heard about, some of the criteria, but also appeals was part of that study. And the stakeholder group looking at all the issues that kind of laid the foundation for Act 181 was a really diverse group. I was on it representing VNRC. There were several regional planning commissions on it, local planners, the Chamber of Commerce, consultants for applicants. And sort of right away, we started talking about appeals. And even though it was an Act 250 group, whenever you talk about appeals, you can't, you end up not just talking about Active 50 appeals, right? Because you've got zoning appeals going to the court, you got Active 50 appeals going into the court, you got A&R appeals going to the court. So everyone starts talking about, well, how can we consolidate and be efficient? Are there efficiencies to be gained? If we're going to change the appeal system, we should change it really for everybody, right? And make it a more efficient system. But right away, the group and the facilitator said, this is sort of a really gnarly issue. There was an agreement on how to do it because there are lots of different ideas about how to do it. And we basically put that to the side. We said, let's focus on these jurisdictional issues, the tiers. We have a housing crisis. Like, where do we want to build? Where do we want to build housing? What are gaps in environmental protections? And that is the heart of Act 181. And that's what passed. And that is why in Act 181, there is an appeal study to just focus on improving the appeal system, to look at it, even though it really is about Active 50, there's a provision in that appeal study that looks at consolidating appeals with zoning and A&R, and to look at how the court handles all of those appeals together. And, so that group hopefully will get together soon. And I don't know I didn't see the testimony from the Land Use Review Board.
Just started.
Yeah, but it really is important because I do think that one of the challenges in just kind of picking off like one or two issues and changing the appeal system is you end up kind of pulling on a thread. There are unintended consequences. It's hard to just focus on limiting appeals, as a way. I understand people's frustration with the appeals process, but if you just limit appeals, you get into debates about, people have legitimate interests and concerns about a project, and they have property rights too, right? And not every person raising concern is a NIMBY or someone who's trying to stop a project. So, how do you balance that, like taking away the appeals rights, but then also taking away the property owner's rights and their ability to protect their quality of life and their property? And it gets really difficult to do that, and to do it in a way that works as intended, So that's why I do think ultimately, and VNRC believes that really the best way to deal with appeals is holistically by going with the study that's coming to look at de novo and record review, to look at can we consolidate some of these appeals, to look at court staffing, to look at the Housing Board of Appeals idea is just one example of, could, certain projects like housing projects where you have a crisis, if you sent them to an administrative board, you could have hearing officers expedite the review. You could look at, issues of party status and who's participating in a holistic way to improve the system. But with that said, we understand, we hear all the concern about appeals this year, and, looked at the committee bill and listened to the testimony about the governor's proposal. And we've identified, at least at VNRC, two areas where this year maybe we can do some work to improve the appeal system while we're getting the study and going to get recommendations to really holistically improve the system next year. And so the ideas that we have are both in the committee bill, and Ellen talked about them. And we do think that there's merit and an opportunity with these two issues. So the first issue is the discussion earlier about any 20 people that could appeal a decision, and we're talking about zoning now. So this is all in the zoning realm. I gave all the background on A&R and Act 50, but the governor's bill and the committee bill really focus on zoning appeal. And for zoning appeals, there is this specific provision that says any 20 people who are residents in a town, if they can get 20 signatures and submit it to the appropriate municipal panel, the Zoning Board of Adjustment, or the Development Review Board, they're parties in the appeal. And there have been various proposals. The governor's bill is to say go from 20 people to 20% of the town. It was a similar proposal last year. So I've always felt that 20 person is a very unique thing to Vermont. I don't know other states that use a standard like that. And as Ellen talked about earlier, I've always thought that it just made sense to basically use the same standard for appeal that we have in Act 250 and A&R and any other legal matter, which is you have to have standing, you have to have legal standing. And what that means is you have to have a specific interest, and it's in our statute, it's called a particularized interest, which is just taken from the case law that's come down from the federal courts. So you can't have a general grievance, like you can't be like, there's a housing project and I don't like it. I don't live anywhere near there and I have no real, I won't be affected by the traffic in that area. But I think there'll be traffic and I don't like it. I don't like that project, or I don't like the way, the idea of a multifamily housing project in an area, even though it really won't affect me personally. That's not enough. You don't get standing for that. You have to prove that the project would harm your interests, your property interests, your quality of life, have some harm to you. And in Act 250 and A&R, the way it plays out, and I represented citizens and VNRC in those proceedings, is you have to get evidence and affidavits. And if traffic is your issue, you have to show how that would affect you personally. If it's a water pollution issue, you have to show that you swim or fish or boat and that would affect you personally. And the other side gets to poke holes in that. And then ultimately the court decides who has legal standing.
You sort of,
Yeah.
you sue, if I understand it.
Yeah,
When you file a lawsuit, when you file a lawsuit, you file what's called a complaint. And you have to put in your complaint who you are. And one of the things you have to put in are what you allege, what you say, the facts that you're going to say are true. And one of the things you have to allege is, why do I have standing? You have to allege, it's going to block my view, or it's going to increase traffic on my street to my detriment. You have to do that. And once you've alleged that, when the trial happens, you have to prove it.
yeah. The way it works in Vermont is like, you don't even get to trial. Like that'll get argued up front. Like they could have someone could ask for a pretrial hearing on it. It's often done in the papers. And the court, does that sort of as a threshold matter because it doesn't have to go forward, right? If you can't prove standing.
Yeah.
Yeah, excuse me, there's a lot of information that you've been talking about, and I'm just wondering, so was it that you support a percentage of the population?
No.
Okay, so
Just going replace,
you support, so currently it's 20
People.
people, and you're proposing what?
you have to show you have standing. You have to show
So
that you're
not changing
injured.
the number.
No,
Get rid of the petition. No more petition.
It's the language. of
Right,
it.
right.
Yeah. People petitioning don't have to show they're even harmed.
Support.
see,
I promote, I did,
I'm confused, and I'm just trying to
Yeah.
understand what you support.
get rid of the petition, get rid of any 20 people who don't have to show they have any harm at all. And just go with,
the 20%, get rid
get
of.
rid of all of it and just use the same standard that we use for Act 250 and A&R. And Act 250 used to have this, if you could assist standard, and we got rid of that. I view that as kind of like 20 people who don't need to have or show that they have any particular interest or harm. They just could sign a piece of paper, basically.
Right, and
you know?
for population differences in different towns or cities.
I don't think it matters. I just think it's.
No, I'm agreeing with
Yeah,
you
yeah.
that it wouldn't,
It could be a lot sometimes.
well, that's what I'm
Yeah,
saying,
right.
South Burlington versus.
He's, as I understand it, what you're saying is, in Vermont, do we have special provisions for abutters?
There's a butters, and then as Ellen
Exactly.
referenced, there's if you're in the immediate neighborhood, which is another weird standard. Ellen actually suggested, which I liked, saying that should be based on standing as well.
Right, in other
Yeah.
words, right now in Vermont, as a general rule, my understanding is, as a general rule, anybody who sues about anything in the United States, the Constitution says that courts are able to adjudicate cases in controversy. Quote, end quote, from the Constitution of the United States. The courts have interpreted it to mean there has to be a real controversy. And to be a real controversy, the plaintiff has to be actually damaged. They have to show that they are hurt in some concrete way. That's the general rule. There's
Mhm.
sometimes when you expand the general rule and say, oh, not that, anybody can sue. What this statute did is it sort of created one of those anybody rules. It said anybody could sue regardless of whether they were hurt.
Right.
Then we upped it to say, well, any 20 people could sue. And the governor's proposal was
Any 20%.
any 20%. And
Yeah,
what
that's. I was
he's
concerned,
suggesting
right, yeah,
is, what
that's
he's
concerning.
suggesting is forget all of the things that relate to anybody. And just require that anybody who sues should have regular standing, which means that they're concretely aggrieved. Yes,
So whether it's 20% or it's 20, you still need the one person to show that they're harmed in some way, or that it affects them in some way.
anybody who sued, you'd forget the 20%, forget the
Yeah.
20, it wouldn't be even.
Well, that's what I mean.
Yeah,
So if you only have one person that's showing that they're affected,
right.
it doesn't matter if you have 20% or you have 20, because it's still that one person that has.
Whoever wants to appeal has to show that. Yes,
So there is a provision for somebody genuinely affected by the project
yes,
to follow through. But it's not so easy for 20 people that are just protesting because they don't like anything built anywhere.
Right, exactly, exactly. Like, I mean, the chair said it perfectly as a former dean of the law school, is the case and controversy that has been the bedrock. And in the, it is due process, basically, like if you can show that you're harmed, you can access the courts to address that harm. But exactly, we, in the statute said, well, you don't even have to show that if you can get 20 signatures. And I don't know why we did that in the first place.
yeah,
Is there like a time frame when you can appeal?
Oh, yes, yes.
Just, oh, okay.
So it's 30 days, you have 30 days and everyone gets notice and you have to meet the deadline. And I just had a case where people missed the deadline and so the appeal was dismissed and they try to glom onto somebody else who was a party and it, we had some arguments about that and they were ultimately not successful, but you have 30 days from the date of decision. If you miss that, it's over.
The immediate neighborhood being applied to this particularized interest. People can have a particularized interest whether they're immediate near or not.
Agree.
So
I agree.
it seems to me it needs to be fair. It needs to be one or the other.
I agree. I think you could get rid of that as well.
They're 5 miles downstream. But
Right.
they're
Just because you're in the immediate neighborhood doesn't mean that you were harmed, right? It really,
and it doesn't mean you could be harmed.
You could be.
by being in.
Right. exactly, conversely. And those are all like when we did ours, these are all vestiges from when we created our statewide zoning laws decades ago.
Right.
Yeah, and I don't know, I'm assuming there was like some model zoning that people were looking at or what have you, but yeah, I would support getting away from that.
Oh, no.
Yeah, okay. Any other questions? Go ahead, John, if you want.
So the other issue that we think has merit for this year, if the legislature feels that it doesn't want to just wait for the study and wants to take some action, is that the administration's proposal to basically tie planning and the right to appeal together, we think has merit, especially given the work in Act 181 around the tiers and the mapping that's going to occur. And, we support good planning. And I think it makes sense to say, if a community, if a region has said in its plan that this is where we want growth, this is where we want housing, in particular, we're talking about the housing crisis, that that should be an important statement in terms of whether an appeal should go forward. So I think as a principle, we think there's something there that could be worked with. I agree with Ellen, I did provide some language which you should look at, and I don't think it's perfect because it's hard to write. It's been hard, but because I think what you want to do is you want to be clear about how you're going to link compliance with a plan with, an appeal not being able to go forward. So the way that it was written in the committee bill and the administration proposal was, I think it said, first of all, it said for a land use decision, which is not a defined term, or maybe that was the residential housing. But I think we should be really limited it to housing, because that's what we're talking about here, right? And I think you should limit it to within. We don't have the tiers yet because the maps are being done, but if you could limit it to where the interim exemption areas are, and then basically be clear about the process. And this is the conversation that you all had with Ellen earlier, that this is not self-effectuating. So someone would have to make a decision. So it would be something like, if there is a project in one of the areas that the interim exemptions apply, that, and you wanted to appeal the zoning permit, you'd have to basically demonstrate either to the zoning board of adjustment or the DRB or to the court that the project, the integration language was a substantial departure from the town or regional plan. I think we suggested that it be a little bit like not consistent with, I don't know what substantial departure, all these things would have to be interpreted over time, but I think the most important point is like, I just want to be clear that there would be a process. You do need someone to decide that, but we think there is merit in saying that if you do want to appeal one of these housing projects in one of these areas that we said we want housing, that you should have to get over this threshold and show that your project might not be consistent with the plan and then could go forward. Something like that.
I just sent you
Yeah.
guys this minute.
And admittedly, the language is not, it's hard to write, and I think the
I
administration.
sent the second.
Yeah, okay.
Okay.
And needs work, and ledge council is better than me at drafting things. But I think that the administration will need to slow down a little bit.
Thank that.
Yes, you have two great legislative councils in the room. But I do think the administration proposal wasn't clear about the process or how this would work or where it would apply. So the point of the language is to basically trying to hone in on where do we want to apply this and what would the process be? And if you can answer those questions in a way that made sense, I think that has some merit. I do want to say that ultimately, I think we would argue for, if you do go down this road, for a sunset on that provision, because I think ultimately, and this is an idea that we got from the chair listening on YouTube, that I think a better approach would be, so we're going to have the tier mapping process, the tier 1A, where there'll be full exemptions from Act 250 for commercial, industrial, and residential development, and tier 1B, where there'll be exemptions for housing in these mapped areas. And I think it makes sense that you should have maybe a requirement that say that you have to participate and raise concerns in that planning process. And if you don't, you cannot appeal a project within one of those tiered areas. And that would basically give due process an opportunity for somebody who has concerns about development in an area to raise those concerns. But if you don't do that, you shouldn't be able to appeal a project.
You're saying you're saying you want to put a sunset on this because you think.
Well, maybe that could come forward, right?
Years in
Yeah.
the report and subsequent
Yes, exactly.
legislation, that's one thing we could.
Yeah, we're gonna have the tiers and we're gonna have the study, and I'd like to be able to discuss that, whether you sunset it or not. I suspect that, we'll come back and others will come back and say, we have a lot more information now. We have these maps and we've got the tiers in the process. And, maybe this is the way to really make sure that in these mapped areas where we are saying, this is where we want growth, this is where we want housing, that we're going to make it harder for you to appeal a specific project in those areas. It'd be better than creating the system of, well, you appeal a project, then you have to prove that it's a substantial departure from the plan, and then the judge has to make that decision, and that could be appealed, and so on and so forth. And I think it would just better tie planning in with the whole regulatory review process, not just appeals, really. And I like that idea a lot. And but anyway, we can't do that right now because we don't have the maps.
Ashley,
How long would you sunset it for?
I think we proposed for 2 years, something like that.
any other questions of John?
Then one more thing
Yeah.
to say, and that is, I don't remember this got into the committee bill or not, but it was in the administration proposal. I just want to go on record that the attorney's fees provision we don't support. The administration said it was based on a Washington statute, and basically the proposal in the administration's bill is that if you're not the applicant and you appeal and you lose, the way I read it is that you're going to have $50,000 in legal fees imposed upon you. The Washington statute, which is based on renewable energy projects that go through both a local and regional review and then the appeal to court is on the record. That was another reason I wanted to kind of lay that foundation. Then, if you could prove actual malice and bad faith, then you may have attorney's fees imposed upon you. So the administration left out actual malice and bad faith. And even with those standards, those have to be interpreted. It just creates something else to argue about. But I just think it's punitive. Like, no one will, it's basically taking away appeal rights because citizens won't. And VNRC, like anybody, the $50,000 is basically a way of like just removing appeal rights. And I just think that's a heavy hand when you have other options, and we're going to get a report that will hopefully improve the whole system. But I just wanted to go on record because that's floating around out there as saying that we don't think that's a good idea, and I don't think that the proposal is. It would definitely have to have a standard like actual malice or bad faith, but that would still lead, I think, to arguments and
So
problems.
if I'm understanding, I'm just trying to get my head around it because it sounds good. Taking that $50,000 legal fees and all that out means that if you have purely agreed, if you've already established that this party has standing, then it shouldn't be necessary for that $50,000 possible fee to be there. It would mean that people with a limited income are just not going to appeal it.
That's right. That's correct. Yeah, that's correct. They just won't.
So,
They'll never do it.
if the 20 people or 20% or whatever was still there, that might make it'd be more of a deterrent. It doesn't seem to be necessary. It seems to be more to shut people down who just can't afford $50,000.
Yeah, you're just shutting people, ordinary people who might have, and this gets back to the issue of like, why it's so hard to do this, because people do have legitimate concerns. Well, there are the NIMBY stories. I know there are, I've seen them. They're terrible stories. Kathy Byer, who's an affordable housing developer, is on the VNRC board. We talk about this all the time. I know what she's been through with the Putney project, but they're not all that. And it's so hard to thread the needle in making public policy that you're, striking that right balance,
So the actual standing eliminates the NIMBY crowd.
Just to sum up, what you're arguing for is generally wait for the study. If we want to respond to interest, to do something in the meantime, we should do none of the things that the administration requires on standing. We should instead just require that anybody have to demonstrate a particularized aggrieved interest, they're aggrieved and their particularized interest. And secondly, that the standard of review, which applies when they get to where they're, to trial having shown standing, is that they have to show it's clearly inconsistent with the planning.
Yeah, exactly right.
And you're raising the interesting issue that sometime in the future, maybe we should consider, because there's a general rule that anybody who appeals has to have participated below. In other words, I don't know, is that true in the de novo review?
It is true, but not in like a planning process, but in the permit process.
Right.
So you appeal a A&R permit, you have to have commented to A&R and raised concerns. Same thing with Act 250. Act 250, you've had to have been a party, tried to have been a party. And I don't know if it works the same, but it works the same for zoning. Ellen is nodding it.
So in other words, it's now a rule all the time, which is so typical, that you can't just decide after everybody else has heard the thing and the decision is made and you didn't go to the meetings and stay till midnight and do all that, and then you appeal. You can't do that. You have to show that you, and the term is exhausted your administrative remedies, that you participated. He is at least raising the concept that someday soon, when we have Act 250 kind of matured and we have these tier 1 and tier 2 stuff, that if a town goes through all the labor of putting together the planning and zoning required to meet that and say, this is where we want housing and this is what we want it to look like, that you have to have participated in that in order to appeal a project.
And raised
But we're not
concerns.
there.
Which would
Or
be
not.
awfully troublesome if you lived in the next town and moved to the next town over after they were done.
Yeah, we talked about that actually, and so you'd have to put in a stand, we taled about that as we were this is the thing, like, as we were thinking about all these things, that's a great point. So you could put in a standard of, and this is the standard for participating in the permit process below. This is what the Vermont law says now, that you have to show manifest injustice, which like means like it was impossible for you to know and impossible for you to participate. But you are 100% right. You'd have to have that off ramp. You'd have to have that ability to do that. But if you lived in the town and you did get notice and you could have participated, you know.
I'm hearing two things, and I like one better than the other. One is you have to participate in the whole zoning and mapping process.
That's the process now.
Okay, that's the process now. So what we're talking about is when you get a notice from the town, you're a butter, and you know that there's been a permit for something and it's warned in the paper record or whatever, that's the time you need to start.
Right, but that's the law now. You have to, when you get that notice, you're the abutter.
Yeah.
You don't show up at the zoning hearing and raise concerns and then you can't appeal. That's the law now.
Now when we're
The planning is not, the planning is not the law now. Yeah,
Okay.
yeah. The chair had it reversed.
And not even, and not, I'm sorry,
Yeah.
yeah, not even, it's not the law and nothing is happening like that. It's not in a bill. It's just something to be discussed.
Yeah, but the law now is, and it was a good change. We did this like, I don't know, like 5-6 years ago, because it wasn't explicitly the law and VNRC supported it. We were like, that is fair. Like you should put your cards on the table, right?
Right.
You get the notice, you should show up.
That's why you get the notice.
Right. And if you don't, you can't just sit that out and then appeal. So that right now, the law is you would not be able to appeal if you did not show up and raise, not just show up, but actually raise a concern. And then you could appeal if the concern is not addressed, you know, in your opinion. But if you don't do that, you can't appeal, whether it's A&R, Act 250 or zoning. You have to do that in all of those processes in order to appeal. And that has been a helpful change.
Okay.
Any further questions of John? John, 1,000 thank yous.
Yeah, no, thank you. And
Just a
Michael-
question for the committee.
Let me just
Oh,
ask one
sorry.
question. Michael, are you here to talk to us or are you here to listen?
This
You're
is,
supposed to have a meeting.
this is part of a meeting that we have scheduled.
Schedule. Thank you very much.
I like to think that Michael would want to come and just hear me ramble on about appeal. You know, but that would be good for my ego.
Sweet.
This is about appeals.
But I'm also a realist, so.
Okay, so this is,
No, I'm trying to ask a question about appeals. What's our next point of discussion on this?
our next point of discussion depends. If appeal, if appeals is to stay under consideration in the bill, our next point will be, we'll schedule a discussion. Appeal sector.
Okay.
With our ledge council.
What Ledge Council would prefer is that we have a discussion and see if we have questions for Ledge Council. And then that, there is some possibility that you won't be able to do it here, because you won't be able to get to drive by an environment, which is where it goes.
I see.
We could do it, I mean, across the hall. I've talked to Representative Lalonde and he's not even sure it would have to come to him. But if it did, he would do one, but it's environment, it's the issue.
So it may be completely scrapped, the
It
bill.
may. Or it might be scrapped for now and come back after crossover when we get the bill from the Senate. The Senate Housing and Commerce Committee has a bill on housing. And that bill will come to us probably when it comes after crossover, when they send us bills. And we have a chance of harmonizing the bill, amending their bill to do, we'll have more time, but it's still an open one. I think we are done for today. Our next, tomorrow, we start at 9 o'clock with a discussion of H57, the survivor benefits. And then we only have 30 minutes, is that right, for that discussion?
That's all you asked for.
I thought it was an hour. Okay, well, we'll talk about that. At any rate,